Good morning. Happy Monday. For those of you who aren't in the loop, the motion to revoke Earl's bond was again continued. Apparently the judge was absent from court. Don't know why. So it was continued to May 14th. So do with that what you will. Now, there's a lot of confusion, or at least I've seen a lot of confusion. A lot of confusion has been directed towards me about the video that Earl made and about the potential for criminal charges to be brought against Earl, for example, for being a felon in possession with a firearm, etc. So I'm going to try to clear some of the misunderstandings that I have seen up. Charges, to the best of my knowledge, have not been brought against Earl for a felon in possession of a firearm. So there is no issue as to that. If charges were going to be brought against Earl for felon in possession of a firearm, then the state would have to show that he had a firearm, an actual firearm. It's not like where you can commit and you can get charged with armed robbery for using a fake gun. It's to be a felon in possession of a firearm, you actually need to have a firearm. And you have to be a felon too. So the state would have to prove beyond a reasonable doubt that it was, in fact, a firearm that Earl had in his possession, etc. But that's not what we're looking at. We're looking at a bond revocation hearing. And a bond revocation hearing in Texas does use the evidence code. So all the normal rules of evidence should apply, although from what I've seen, it appears that county by county and courtroom by courtroom, there are changes on how each judge does bond revocation hearing. So I take all of this with a grain of salt. I can't research specifically what Earl's judge is going to do, but to the best of my knowledge, all of the rules of evidence are in play, which means that if you want to get something in front of the judge, you're going to have someone testify about it. For example, in order to get the video of Earl in front of the judge, someone's going to have to authenticate the video. Someone's going to have to say, yeah, I downloaded this off of YouTube on this date at this time from this URL. And then, unless both sides waive that, I guess technically both sides could say, no, we'll stipulate that is actually a video of Earl saying that he has a firearm. Now, the video of Earl saying that he has a firearm is an out of court testimony. It is a statement made out of court where Earl says, I have a shotgun. I'm getting my shotgun. So you say hearsay. They're going to try to keep it out as hearsay, but it is a statement of a party opponent. So the state can bring it in because Earl said it. It's a statement made by a party opponent. It's not hearsay, or there's an exception to the hearsay rule. Depends on which way Texas phrases it. It's not really a big deal either way, but it can come in. And case law in Texas shows that just an out-of-court statement, an extrajudicial statement by the person whose bond is going to be revoked is sufficient to justify the bond revocation. And, there's a lot of reasons why it wouldn't be sufficient to convict. Number one, you have to prove beyond a reasonable doubt. Number two, the corpus delicti, you have to prove that the actual crime was committed, which means that you probably have to turn up with a firearm and say this and prove that this is the firearm that Earl had, etc. So there are a lot of reasons why Earl's statement is sufficient for a bond revocation hearing, but it's probably not sufficient by itself for a conviction. But he's not been charged with it, so there's no worries about that forthcoming. As far as the schools or the safe zones violation. Earl is mistaken on that as well. Oh, by the way, can Earl's statement about this was just let's go back to the gun thing. Can Earl bring in his video about him saying, well, it's a paintball launcher? No, he can't. Because that's not a statement by a party opponent. It is an out-of-court statement offered for the truth of the matter asserted, but it is not subject to any of the hearsay exceptions. So it would not come in. In order for Earl to get that kind of information in front of the judge, most likely Earl would have to testify, or someone else would have to testify that, yes, I saw Earl with this. Yes, it looked like a firearm, but no, it was in actuality a paintball launcher. So someone's probably going to have to testify, and I would hazard a guess that Earl's attorney is going to be reluctant to put Earl on the stand because Earl already has a credibility issue, so his testimony isn't going to be very good, and he has a lot of reasons to lie, and it's going to be Earl's testimony versus Earl's testimony, and which do you think the court is going to believe, the exculpatory testimony or the incriminating testimony? And I would hazard a guess that the court is going to believe the incriminating testimony and not the exculpatory testimony. And one other thing that you need to be aware of is that Earl does have a conviction, felon with a firearm conviction. So that does show a propensity, and that is something that can be brought in because it does show his propensity to be a felon in possession of firearms. So, I mean, theoretically, the judge could say that he's excluding it because it's more prejudicial than probative. But quite honestly, since it is going to be heard by a judge and not a jury, there's no real reason to make an evidentiary objection to it. The judge already knows Earl's criminal history. The judge already knows that Earl has a felon with a firearm conviction. I guarantee it. So trying to keep that from getting in front of the judge again isn't going to get you very far, I don't think. So let's go back to the safe zones. Earl's bond condition, from his amended bond condition, I guess, is because he is being charged with sexual assault on a minor aged 15 to 17 or something like that. Because of that, he is required by the conditions of his bond to not go within 1,000 feet of a safe zone, like a school or a park or something like that. Now, Earl seems to believe that there is some exception that the judge stated for his work, and I am going to hazard a guess, a very educated guess, that no such thing exists. The way orders work is that unless you have an order amending the judge's order is the order. It doesn't matter what else the judge says. The order is the order. The written order is the order. And it also doesn't make sense that the judge would give Earl permission to be within 1,000 feet for work purposes, because you got to, like, for example, if someone was restrained from being within 1,000 feet of a school or what have you, but they worked at the corner of the street that was like 900 feet away, and so they barely had to get within 1,000 feet to do their job at the physical location where their job existed, then there is a chance that the judge would say, except for going to and from work and being at work, specifically at this specific address, then you can't be within 1,000 feet. The judge would write it into the order, and the judge may make an exception. But Earl doesn't go to work at a specific location. He goes to work wherever there are cops, either to bait them or to get baited by them, depending on whichever way you want to look at it. So the odds of a judge actually writing that in are somewhere in the slim to none range. So I don't think that exists. And again, I haven't seen any amended or second amended order or whatever they would title it, changing the bond conditions. So, and I haven't seen a subsequent hearing on on this schedule showing that they went back in for an amendment to the bond conditions. So I don't believe that to be correct. As far as the final one, I haven't seen the order on the CPS documents, paperwork referring to them, whatever the order was. I haven't seen it. And I also haven't seen what Earl said or showed or did. So I can't speak intelligently about that. But there is a strong likelihood that Earl will get his bond revoked based on the firearm, because that's showing danger. The going within 1,000 feet of the protected zones also shows danger. Apparently he went there multiple times. With something like that, though, I can imagine the judge saying, well, you made a mistake. You thought you could go there for work. You can't. I want to be very clear. You can't go there for any reason. So I'm just going to smack your hand this time and send you back out. I could see that happening. Courts tend to be extra liberal with second and third chances nowadays, especially with COVID, keeping all the jails full. Anyway, but the firearm thing, firearms are scary, and felons, especially if they're out on bond, shouldn't have them. So thanks for watching. Hope this was informative. Have a great day.